The Law Factor with advocate Clarence Arenas-Gandawa.
Greetings of the day. Let's begin with the machinery of survival. Climate change is not a distant storm. It is the daily weather of our lives. Floods wash away homes, droughts parch the soil, storms rewrite economies. But pause. Who pays for this damage and who profits from the destruction? Climate law is not about abstract treaties, it is about survival. It is about whether corporations treat the earth as a partner or a dumping ground. When companies pollute rivers, burn forests, and emit unchecked carbon, they gamble with the future. And when law is silent, profit becomes poison. Now, the carbon ledger: emissions versus equity. Corporations emit, communities endure. Factories profit, villages perish. And so we must ask, who measures emissions? Who enforces penalties? Who protects the vulnerable when profit collides with pollution? Justice must not be a ledger of fines. It must be a covenant of preservation. Because when emissions rise unchecked, equity collapses. And when equity collapses, democracy itself is endangered. And then the case study, the polluted river in Lusaka. A factory discharged waste into a river. Villagers lost crops, health, and hope. The company paid a fine, but the community remained broken. This is not accountability, it is tokenism. It is the monetization of misery where penalties replace protection. Climate law must demand restoration, not just retribution. Communities must be healed, not just compensated. To the judicial responsibility, courts as climate guardians. Judges must do more than interpret statute, they must defend the planet. When corporations pollute, courts must demand full restoration. When communities suffer, courts must insist on reparative justice. Because environmental harm is not just a violation of law, it is a violation of life. The robe of the judge must become the robe of the guardian. The gavel must strike not only against crime, but against climate negligence. Let's talk Parliament. Legislating green discipline. Parliament must legislate with discipline, not delay. It must draft laws that require carbon taxes that make pollution costly, mandatory sustainability reporting that makes corporations transparent, strict penalties that make ecological harm unprofitable. Because when statutes are vague, corporations improvise. And improvisation is the enemy of equity. Legislation must be the compass that guides profit towards preservation. Now we speak to the public. Environmental literacy is civic power. Citizens must know not just their rights, but how to defend their rivers, forests, and air. They must know how to report pollution. They must know how to demand environmental justice. They must know how to hold corporations accountable. Radios, schools, churches, chiefs' councils, these must become classrooms of climate justice. Because silence is not ignorance, it is design, and we must redesign. We move to Eswatini in focus and the continental mirror. In Eswatini, environmental laws remain fragmented. Citizens rely on verbal instructions, not digital platforms. Kenya enforces plastic bans. Nigeria debates carbon taxation. South Africa experiments with green finance. Eswatini must not lag, it must lead. Climate law must be written not tomorrow, but today. Climate negligence is a corporate crime. Pollution is not a side effect, it is a violation. And law must treat it as such. Because when corporations destroy the planet, they destroy the people. Don't just demand profit, demand preservation. Don't just accept fines, demand restoration. The law must breathe louder. The law moves forward, you must move with it. See you next Thursday. The work continues.
Springfield Law Clinic, justice defined, rights protected. We are here to serve.